So as we wait for rest of the audience to join in, I will briefly take you through what Scimplify does, because this is one of the initiatives from Scimplify. So who we are, why we are here. So I just wanted to explain basically what Scimplify does and how it can support you in general terms for next maybe 5 minutes. And then we can get into this webinar. So Scimplify was established in November last year, and we are around 7 months old company now. But our way of resolving the pain points within the industry that we want to fill the gaps is through science first manufacturing of chemicals. Specialty, it can be pharma. So we are having multiple verticals within Scimplify. So coming back to our original requirement, the original part, so we have an innovation lab in ICICI Knowledge Park, Genome Valley, and we are at Touchstone 270 building. So we have an innovation lab led by Dr. Prem, who is our chief scientist. So we help in sourcing of raw materials, developing these raw materials and manufacturing these materials for pharma as well as other industrial users. So that's where we, as a platform, we are a science-first platform on getting these. So we help you in discovery, development, manufacturing, and scaling up on commercial scale. So that's the ideal way that we can put ourselves in. And we have multiple capabilities across the value chain of a product, where we as a Scimplify, we can start with custom manufacturing or even development for intermediates or raw materials that are currently not available in India. So we wanted to help our manufacturing partners in doing these innovation of these chemicals and get the best out of with respect to cost, with respect to the technology, to the available manufacturing partners, scale it up, do proper process validation, do a tech transfer, and do a commercial manufacturing. So today we are working with across 150 MSMEs who are our manufacturing partners, and we work with them in filling their gap, especially on the innovation side and the technology side. And also we help them in marketing their products which they have built in their plants. So that's how we have cross-pollinated across from research to the commercial manufacturing. And this is a dual way of helping Indian industries, especially the Indian chemical industry, where we wanted to seriously substitute Chinese imports in this case. So why Scimplify? Because we do sourcing ourselves. So we have our own strong SCM team who does sourcing, and we find first best places within India and for all the raw materials. And then we also have tech-enabled project management that is built into this system. So whenever there is a client coming into on the platform, they can source through what is the project status directly. There will not be a human interference. There is a tech interference that we are building up, and also having a technology bank, research talent within the system, and the fungible manufacturing capacities that are today available in India but not being utilized properly. So that is why we are putting all these points together and building this platform. So what are the industries that we are catering today is pharma for active ingredients, intermediates. We are also working on agrochemical side. This is a different vertical that a different team works at. we have industrial chemicals and flavors and fragrance. So literally we are covering up all the chemical industry, especially in the specialty chemicals. So that's a brief about Scimplify. And in any case, if you want to contact us, do let me know. This is my mail ID and this is a phone number. Coming back to our point, it's almost 4 minutes, so we have around 19 participants. So, so I would welcome you again and thank Dr. Pavan to take up this topic. So Dr. Pavan is a senior scientist in chemistry and IPR. He works at CSIR, Institute of Minerals and Material Technology. He is an active member within strategic planning, business development. He's a coordinator and conveyor for intellectual property rights, and also does a lot of work within innovative technology enabling center, and also part of standing ethics committee member within these organizations. And Dr. Pavan, I would like you to introduce yourself, please.
Thank you, Karthik. Good morning to all the participants present here. And I was happy to know about Scimplify, the kind of services or the kind of practices that you are following, and appreciate your efforts. And I also thank Dr. Pavan Kumar, who was my senior during my PhD days. And now I'm happy to be part of your efforts through this program. And from the participants list, I could find many well-known people with whom I have been associated either during my PhD days or later on. And thank you all very much. And I think my introduction, I'm MSc and PhD in organic chemistry from Osmania University, but PhD work carried out at CSIR-IMMT. Then for a short stint, I was there at Dolcera, an IP firm. That is where I could realize the value of IP for academics and research, and then I could make it as a parallel practice. Meanwhile, I could pursue some courses, I got some certifications. Then I joined IICT again as a DST Inspire faculty. That is where we could able to integrate our patent learnings with research, whereby we could file about more than 20-25 patents during that time. And luckily, a few of our earlier patents were also licensed to Sun Pharma, and we could attract some royalties. So with this experience in hand, and wherever I go and interact with the people, either in academics, research, or industry, we always try to encourage people around us to look into the aspects of IPs, and wherever there is a scope, better always take an IP first, followed by the other activities. And we always try to conduct the programs or conduct the sessions on IPR with the theme IP for all. So this is my brief background. And meanwhile, by now we could file more than 40 patents from different areas, where I was involved either as a core team member or an associate member. So I can confidently say that it is because of my presence that work has been converted into a patentable outcome. So with this background, today I wish to conduct this session on the aspects of patents, mainly for R&D outsourcing. That is what the title suggested.
But yes, Doctor. Today's topic is key strategies in protecting IPR in R&D outsourcing. So the whole idea in bringing so many scientists and people across in the audience is the topic of interest coming from the industry, because most of us as a chemist, we know that how important is intellectual property rights in this chemical industry and especially in pharma. Most of us know basics of it, but still we don't have the required knowledge or required know-how within this domain. So that's the reason I think this is a good topic, and also for the first level of in webinar from Scimplify. This was one of the thought-provoking topic, and I see a lot of good responses even already coming from in terms of number of audience pitching in. I think these topics, there are different topics that we are also curious about how the patents are done, what are the things. So we know basics, but still from an industry expert, we would like to understand what is a product patent, what are the general patent claims, how we do, what is an evergreen patent. So these are the different topics that we are trying to cover in this session. So first, I would request you to briefly take us through the process on the patent side, and then maybe we can have an interaction on this.
Yes, Karthik.
And before we just move on, Dr. Pavan, I would like to the audience to chat their questions as we are speaking on. So we'll curate these questions at the end of the webinar. So we are planning to have this webinar for about an hour. So we'll keep it before for 45 minutes on the discussion part, and maybe the last 10 to 15 minutes will be the Q&A sessions. So you can just chat and drop your questions, and we'll curate it at the end of this session.
So fine, Karthik. So what I do is quickly I'll just introduce what is called IP, different types of IPRs. Then I'll take you through the concepts of patents, and maybe I'll touch upon the essential aspects of the patents. And I hope, and if the participants find it known subject, then do let me know so that we can skip those slides. Okay. I just thought of giving an overview of the essentials on patents. Let me share my screen.
Yes. Dr. Pavan, I would request that because there are a lot of people even from Scimplify, and most of us doesn't know the basics, so it would be better for us to even brush up.
Okay, fine then.
Yeah.
Fine. I'll do that.
Yeah. Thank you.
Hope my screen is visible, right?
Yeah.
Okay. So, and this is my brief biodata. I am also a visiting faculty at ISIR Berhampur and ICT Mumbai Bhubaneswar. And these are the places from where I got my education, training, and working experience, both in terms of chemistry research as well as IP. And here is the outcome. As I was mentioning, the left-hand part is quite common for any researcher, but the right-hand side, finding some patents, some technologies, then commercialization, those things are very rare, which we could achieve only because of integrating our IP learnings with research. And please look into this slide. IP as a subject is relevant to each and everyone. It has got applications in every sector, every field, and every occupation, each and every occupation. Since we call it as a property, like any other properties, we can exploit this for our benefits. It can be sold, it can be bought, it can be leased or rented, it can pass under will, it can also be assigned. But there are certain limitations. And because of these certain limitations, IP is generally referred as limited time enjoyment right. It is a limited time enjoyment right, and the major limitation is the time limitation. And here is the broad classification. It is two types broadly. One is copyright, the other one is industrial property. Again, industrial property depends on two factors. One is information, the other one is innovation. For Scimplify, I think both the factors are really essential here. Because whenever you do R&D works, or you develop process, or you take up projects, you might come up with some innovations. So there's a possibility of obtaining patents or keeping them as secrets or going for industrial designs. With respect to information, the trademark and geographical indication. Geographical indication may not be that relevant for you, but certainly the trademark. The Scimplify, your logo or the name by which your services or your products are identified itself is a trademark. And the other kind of IP is copyright, where the rights of the authors as well as rights of the performers are protected. On the left-hand side, I tried to show you the different types of IPs with an example each. And through this flowchart, we can easily understand how an IP can be realized. In general,
please, other can you mute? We are getting disturbance. Karthik, you can make all in mute to Karthik.
Muting.
okay. I think I am audible, right?
Perfectly.
Okay, fine. So you please see this very simple flowchart. Whether you believe me or not, everything starts with an idea. It is the idea which is considered as the source of the kinds of IPs that we can realize. So idea, if it results into a work which is expressive in nature, you may get a copyright. Idea resulting into invention or innovation, you may get a patent. Idea reflecting the quality and identity of a product or of a service, it may be a trademark. And idea, if it results into appearance, a new appearance, it may be a design. And then idea, keep it secret, do some trade, preferably make some profits. It may be a trade secret. But here, it is not just an idea through which you can obtain IP, but you need to convert your idea into a workable idea. So once you get an idea, it has to be converted into a physical outcome. Only for that physical outcome, depending upon the nature, you might get some IP. And here is the time limitation. As I mentioned, intellectual property rights are limited time enjoyment rights. Patents are 20 years, provided if they are granted. Trademarks, designs, and geographical indications, initially for 10 years, you will get the rights. But however, there is a possibility for the renewal. Trademarks, you can renew as long as you wish to keep them. Copyrights, lifetime of the author plus 60 years. Again, there are two more kinds of IP, like plant protection and integrated circuits. Their protection is anywhere between 10 to 18 years. Once the given time period is over, you cannot do anything. So done is done, and after that, your property becomes an open property and anyone can exploit it. Just look into this slide. Take the example of Coca-Cola. There are at least five different types of IPs associated with this. The name and brand is a trademark. The ring pull system is a technical aspect which is protected through patents. And the inventor of this ring pull system, he used to get 148,000 UK pounds per day on royalty. Because he has patents, he has licensed his patents. And the original composition of Coca-Cola is a trade secret since 1886 or 1880. Yes, 1886. And creative content is a trademark, and the design of the bottle, the shape of the bottle is protected as industrial design. So this is how a given product can be associated with several types of IPs. Now, having this background, now let us look into the patents. In my opinion, patents are considered to be the most relevant forms of IP for the people like us. If you are from academics or industry or from research, yes, it is patent which is more and more relevant. In simple terms, it can be defined as a contract between the government and the inventor. You have invented something, you registered your invention with the patent office in the form of a patent application. Once it gets granted, you will get the rights. So the government gives the inventor the right to exclude others from making, using, or selling the invention for 20 years. So it's a simple contract between the government and the inventor. And it is also regarded as a techno-legal document. When we say it as a techno-legal document, yes, it is very much correct, because we all might be very, very strong technically. But once you start making a patent document, you may not satisfy the way you are making it, because it also includes a legal component where we do not have proper expertise. Not only these two, the third and most important factor is integration of these two, integration of the technical as well as legal aspect. That is even more important. So therefore, patent is regarded as a conditional grant. It has got balance of rights and obligations. It is also subject to other laws of the land and always granted to the owner of the invention or the assignee. And we still have a misconception that these patent practices are very modern practices or new practices. Believe me, these are not the new practices. The terms or the kind of words we are using to address this topic might be new or modern, but not the practice. So ancient Greeks, somewhere in 500 BC itself, used to grant protection to the inventors. So this is one of the oldest practice. And these are the top 5 countries which are performing very immensely, like in terms of patent contributions worldwide. See, China, US, Japan, Korea, and Europe. The first patent from US has come in the year 1790, that too for a chemical process of making potash. And Japan started filing patents somewhere in early 1900 onwards. And Korea and Europe also started like after US and Japan. But China, if you see the China, they only started, the first patent from China has come in the year 1985. Before 1985, there was no patent in China. But then within soon, it could emerge as the most patent filer of the world, followed by US, then by other countries. And just to give a quick example of the impact of patents, now cricket fever is going on in the country. This used to be the case once upon a time. Then came the sensor-based stumping systems. He is the person. Single-handedly, he has invented sensor-based stumps. Now he controls the entire cricket ecosystem of the world. And I have put the front page of the patent that he has filed at the International Patent Office, and also the title. Look at this: a system for indicating movement of an article from one position or orientation to another position or orientation. By looking at the title, you do not realize that he is talking about sensor-based stumps, right? But his invention is about sensor-based stumps. So this is where we need to get trained on converting our research works into patentable outcomes. So this is the reason why patent is a techno-legal document. Technically, you have to describe your invention, but to get a proper protection, you have to define it legally. And I don't know whether you have gone through a patent document or not, but believe me, any patent document can range from starting with 2 pages to 200 pages or 2000 pages. I have seen a patent document with more than 900 pages. Irrespective of the number of pages, a given patent document can be divided into 4 major parts. The first page is always referred as bibliographic data, where you can find the title, some numbers, dates, class codes, names, etc. And then comes the drawings. In case of chemical or chemistry related patents, there may be a retrosynthesis or the process route or the flowchart. Then the third part is description. Again, description has several subdivisions like field of the invention, background, summary, detailed description, and finally the claims. First 3 parts are regarded as the technical parts of the document. The fourth one, claims, are the legal parts. And this is how, if you ask me the importance of patent, this single side itself attests the answer. First 3 parts are also called as disclosure, which is very, very important for the public. But for you as an inventor, it is the claim or the claims which are more important. It is through claims you get the rights. It is through claims you get the protection. Quickly, I'll show you one patent document. This is the the page where you see the description part, drawings and the prior art, and then the detailed description, detailed drawings, and finally the claims. Always claims will appear at the end of the patent document. Front page will be bibliographic data. The last will be the claims. In between, you will find the drawings and description. Quickly, irrespective of the country where you have filed the patents, there are some factors which need to be looked into to retrieve as well as to analyze the given patent document. I have marked them in red. Please see this. This is a GBA and some class codes are there here. Similarly, PL, B1 and this. Right? And some of those patents are not in English language. Similarly, here AU, B2 and these codes, EP, B1 and these codes. And here CNA and these codes, and CA, A1 and the codes. Right? And you also look into the structures. This structure. Okay. There is a correlation with respect to the kind of code or the kind of 2-letter country which is appearing on the front page of the patent document. When you talk about Indian patent, see IN is here, A is here, and these are the class codes. And what do we mean by these? First, let us start with what is called class code. You have found some patents with A. When I say A, it can be A, A1, A2, anything. B, E, and D. These are the common codes which appear in the patent documents. Believe me, whenever you come across a patent document with the patent number having A, it is not a patent at all. it is not a patent at all. It is only a application or published application. Only when you find the number with B, when I say B, it can be B, B1, B2, anything, that is called as patent. Only granted application is called as patent, but not others. And many a times people get confused. If once they get some number with the patent office with A, they start showcasing that we have patents. No, that is not a patent at all. And if you find E, it is reissued patent. And if you find D, this is a design patent. Of course, design patent is not in the Indian practices. It goes with American practices. You don't find any patent with D in terms of Indian practices. And with respect to country codes, all the countries that are following patent practices are represented with 2-letter country codes, like IN for India, JP for Japan, US for United States, likewise. These country codes are very, very helpful while searching for patents. If you search in a patent database by using the full name of the country, you may end up with 0 results. But it doesn't mean that the results are really 0. You have to use 2-letter country code. And the third one, I was mentioning about the codes, some other codes. Those are called as technical codes or technical classification codes. There are 4 major systems of classification: American system, European system, International Patent Classification System, and Japanese system of classification. IPC is International Patent Classification. You will find codes with respect to IPC in all kinds of patent documents, irrespective of the country from where it appears. But coming to US, European, and Japanese, you will only find these codes in those respective countries, not in all documents. Why IPC is required? You might have noticed some of the patent documents or the patent applications were filed in non-English language. So therefore, it is language independent, terminology independent, and is a standardized application to all the documents. This is very, very helpful in retrieving the relevant patent documents related to our invention. As on today, the entire the entire system of patents has been classified into 8 major sections. These are the 8 major sections under which all inventions filed for patents will be counted. And there are 12 levels of hierarchy under each section. The importance of finding a relevant code is like this. If you perform a patent search by using this code, you may end up with 34,000 documents. But if you can further narrow down to find out the relevancy, you may end up with only 607 documents. If still you can further narrow down to the more relevant concept or relevant invention, you may end up with only 98 documents. Here, searching and analyzing and understanding 34,000 documents is not that easy. But because of this international patent classification system, your job is becoming more and more easy. And here the trickiest thing is to identify the relevant classification code. If you can identify that, your job becomes more and more easy. And there's also another term called as patent family. An invention can be filed for patents in more than one country. For example, if you have filed a patent, if you have filed your invention for patent in India today, and meanwhile you also file patents in other countries, like 4 or 5 other countries, invention is same, but there are 4 other applications apart from Indian Patent Office. So all these 4 patent applications filed in other countries for the same invention are referred as patent family. And then comes the patentability criteria. It is not that based on your wish, you can go and file a patent application at the patent office. Of course, you can do that, irrespective of whether it is really a patentable invention or not. But then, if you're really keen to pursue your invention for granting, to the extent of granting, then you need to be very, very careful enough before you attempt in filing the application. It is you who can decide whether your given invention is a patentable invention or not. There are 4 major criteria which need to be looked into for assessing the patentability. They can be referred as NUNS test: novelty, utility, non-obviousness, and statutes of the nation. The first three criteria, novelty, utility, and non-obviousness, are quite common for any country. But the fourth one, statutes of the nation, is also common, but it might differ from country to country according to their patent law. And novelty means it should be new, entirely new. It should be known for the first time. That satisfies the novelty. Utility means it must have some or other applications in any industry. Satisfying utility is also quite easy. But inventive step or non-obviousness, this is where many people find difficulty in satisfying the criteria of non-obviousness. Something which appears to be obvious to a person who is ordinarily skilled in the art. If so, it is not patentable. So they should not find it obvious. Proving inventive step is little difficult. Otherwise, patentability criteria assessment is one of the easiest job. The fourth one is statutes of the nation. Again, here, with respect to Indian Patent Act 1970, there are two sections, Section 3 and Section 4. Any invention listed under these two sections, irrespective of whether it is novel or having utility and is also having inventive step, it is not patentable, because Indian Act or Indian laws do not allow these kind of inventions to be patentable. So you need to make sure that your invention should not fall under Section 3 or Section 4. And what are the non-patentable inventions in India? These listed inventions, whatever I am showing on the screen, if your work or the project or the invention falling under these categories, it is not patentable at all. Better not to put any efforts towards filing patents. Any inventions which are frivolous or against to the nature, or just they are talking about the discovery of the known things, or new or a repeated property of a known substance, mathematical or business methods, method of agriculture and horticulture, any process which is like which involves only a mental process but not a industrial application, compounds obtained by admixture or just bringing them together with no further improvement, presentation of information, traditional methods, method of diagnosis, treatment or operations, methods related to atomic energy, computer softwares, or arranging or rearrangement or duplication of the known devices or known components to get the same result. So all these kinds of patents are not allowed in India. So then this is the slide where I wish to comment that knowingly or unknowingly, majority of us are in this phase, a phase of transition. If you are from academics, yes, you are 100% in this phase, because we have the habit of doing research and putting them in publications or submitting the reports to the agencies which supported us. But now everyone is talking about the patents. Not only everyone, even the organizations, even the government is also insisting to go for IP. And even if you are from industry, many times we keep them as know-hows without really going for obtaining patents. So now the time has come for us to take a proper to adopt a proper strategy. Believe me, whenever you feel that you are in a transition phase, always try to take an IP first. Try to take a patent first. By obtaining patents, you can also get publications for the same work. It is like 1+1 offer provided if you take patent first, but the reverse is not possible. Then comes the claims. As I mentioned to you earlier, it is through claims you get the rights. So, and claims are tested before granting by the examiner. And claims are the exclusive or legal rights given to the inventor when they file the patent, and provided if it gets granted. Always please remember, invention is defined by the claims. Whatever you put in the description part or the other parts of the document, yes, they might be required, but they are not that essential for you to obtain a protection. You get the protection for your invention only through the claims. And claims have a certain structure to be followed while constructing them. Please see this. A claim can be divided into three major parts: preamble, transition, and the body. Preamble names the invention, whereas body includes all the elements that will build your invention. Transition is something which connects these two. So therefore, it introduces the elements and limitations that make up the invention. There are two kinds of transition again: open transition and closed transition. Open transition is like open transition gives a wider range of coverage, whereas closed transition gives the narrower coverage. I'll talk to you more on open and closed in coming slides by taking one or two examples. And here is how the entire game of invention and its protection can be depicted. If this is your invention, the yellow one boundary is the claims. It is the strength of your boundary which determines the scope of your protection. If your boundary is strong, your invention is strong, and you can exploit it for your own benefits. Otherwise, people can very well exploit your invention without your consent. And again, coming to the claims, there are two major types. One is independent claim and other one is dependent claim. Always the very first claim of any patent document will be the independent claim, which stands on its own. Dependent claims always refers to the earlier claims. And here is the list of claims that generally we come across. If you develop a product, the patent is called as product patent and the claims are called as product claims. Process claims and process patent. Markish claims, especially for chemistry people, Markish claims has got a greater advantage. You may develop a 30 compound library, but that is not the limit. You can go for 30,000, 3 lakhs compounds also. But physically or practically making 30,000 or 3 lakh compounds is very, very difficult. So therefore, there's an advantage in terms of having a Markish claim. You develop some compound library, but try to protect your invention through Markish claim, which is regarded as a generic claim, which includes large number of specific structures. And then comes the Jepson claim. If you improve upon the existing processes or existing products, and if that improvement is a significant improvement, you can go for filing a patent for the improved version. And in those cases, the claims are referred as Jepson claims. And the other one is Swiss claims. You all would have noticed during the times of COVID, Favipiravir and Remdesivir, they were repurposed for treatment of COVID. But however, they were already known for some other treatment. So therefore, second and further medical use is regarded as Swiss claim. If you claim for second and further medical use, those kind of claims are called as Swiss claims. However, Swiss claims are not allowed in India. And these are the claims that are allowed in India. Product claims are allowed. Process claims are allowed. If you develop a composition or a formulation, yes, that is allowed. Method of treatment not allowed. New physical forms are generally not allowed unless and otherwise if they show enhanced therapeutic efficacy. And you all might be knowing the famous case of Novartis. And as on today, no one knows the definition of what is called enhanced therapeutic efficacy. And then living organisms are not allowed except for the microorganisms. There's also another kind of claim. Product by process claim is also allowed in India. And here is how one need to construct the claim. There are three major terms that one need to understand while constructing the claims for an invention: embodiment, claim, and invention. Invention is a very broad perspective of your idea, which only has got a mental construct with no physical appearance. Claim is something where you wish to protect your idea through experimentation, and it is the embodiment which reflects your original experimentation. So if you, whatever experiments you do practically, they constitute your embodiment. But when it goes for claims, you can have a broader coverage, and invention is much broader than your experimented examples. So we generally refer it as a double funnel approach. And then coming to the patent filing process, here is the flow chart. The day you go to the patent office and file your application, whether it is online or offline, that is called as filing date. And in some cases, it is also called as priority date, provided if you go for provisional filing. And within 18 months, it will be published. During this time, it will be a secret between you and patent office. No one will get to know what exactly has gone into the patent document. Only after it gets published in 18th month, anyone across the globe can see. And once it gets published, in about 24 months, it need to be granted. But however, in practical sense, in India, it takes about 3 to 4 years, sometimes even more than 4 years. If your patent gets granted, then it will be valid for 20 years from the date of filing. So the entire time period of patent validity will be 20 years from the date of filing. And from the date of filing to the date of grant is generally referred as office action. The reason being, patent office role will be very much there for to and fro activities. And here is how the patent filing and associated fees are there with various activities. If you are a startup or an individual or an academic institute, patent filing fees is 1,760 rupees. And for the big industries or the organizations like us, R&D organizations, it is 8,800 for physical filing. If you go for online filing, there is 10% reduction in these fees. Once you file the patent application, within 18 months, it gets published. And suppose if you are not ready to wait for 18 months, you want this to be done quickly, you can opt for early publication by paying some extra amount. So like Tatkal passport. So by doing so, this 18 months can be reduced only to the extent of 1 to 3 months. Within 1 to 3 months, your patent can be published. And then as an inventor, it is your duty to request the patent office for examination. If you file request for patent request for examination, then only your patent will be examined. Otherwise, it will be kept as such. And there is certain time period. Earlier, it used to be 48 months. But now in the recent amendments, they have reduced this time period to 31 months. Within 31 months from the date of filing of your patent application, you have to file for request for examination. This is the fees. Then it will be examined. After examination, you will get the first examination report, which in general terms called as FER. And after that, you need to reply within about 6 months. Again, if there are any objections, they will go for re-examination. Sometimes they may also go for hearing. After all these things, if it gets granted, you can enjoy the rights. Otherwise, you have to forego your application. And these are the different fees again. Whatever 1,600 rupees I mentioned or 1,760 I mentioned, 30 pages and 10 claims are allowed with these fees. More than 30, any page more than 30 and any claims more than 10, for each page and for each claim, there is a separate fees. And after the granting, every year you need to pay the maintenance fees. First 2 years, there is no fees, but from third year onwards till 20 years, you need to pay the maintenance fees. Again, the fee structure is different for individual, startup and academics as one set, others as another set. And with respect to international filing, Karthik, I may take another 5 minutes.
Yes, doctor.
So there is with respect to foreign filing, there are two routes. One is Paris Convention route, where there are more than 100 countries by now. File in India today, within 12 months, you need to enter into those selected countries. That is one process. Another one is PCT, which is also called as International Patent Application. File in India today, within 12 months, you file a PCT. With single application, you can retain priority in more than 170 countries, and you will get additional time of 18 months to decide in which countries you wish to take it forward. But at the end, patents are granted by national patent offices only. And there is nothing like international patent, there is nothing like global patent, there is nothing like world patent. There is only something like international patent application, but not the patent. And quickly, I'll show you some of my own examples. So as being an organic chemistry researcher, we always try to design and develop small molecules for various biological applications. See, the structures I am depicting here are marked structures. We made only 20, 30 compounds, or sometimes only 10 or 20 compounds. But by the way, we depicted the market structure. Whatever may be the number of compounds, all are protected with our market structure. For most of these works, we file patents. So these are the front pages of our PCT applications. And these are few more works like natural product analogs, a process for nicotine. And this is the work for which for the first time we filed patents in 2015. And by 2019, we could able to license them to Sun Pharma, and IACT could receive about 5 crores royalty. So with this motivation, we always try to file patents. These are the front pages of 2 American granted patents from some of our works. And these are the terms one need to practice publication between publications versus patents. Author, manuscript writing and affiliation goes with respect to publications, whereas inventor, specification, drafting and assignee goes with respect to patents, because patents are the techno-legal documents. And of course, I need not talk much on this. Our research orientation, knowingly or unknowingly, has been towards this. Of course, maybe this may not be true for the industry, but especially for the academics. But now the time has come for us, whether you are from academics or from industry, this need to be our orientation. India first, innovation first, and IP first. So IP is more and more essential, because whenever you find some new thing, some new innovation, always you should take an IP. And these are some programs which we keep conducting to nurture people around us on the aspects of IPR. And this is one of the upcoming program which we are planning to conduct in the month of June. And most of these programs are very successful. And with this slide, I wish to conclude my session. We all know that a educated person or a knowledgeable person get respect, get value wherever he or she goes. But in similar lines, what I feel is Anusandhan Sarvatra Vijayata. If you have an innovation, you can see success wherever you go. And these are some memorable interactions with eminent people in science and technology. And I could associate with them very closely. It is not just because of chemistry, it is majorly because of my IP. So with this, I just stop here. Thank you.
Thank you. Thank you for this good inroads into how we protect our IP and how these claims can be done through the patents. So coming back to our things, now we'll have more of an interaction, Dr. here. We have also one question, but I will take you through that question afterwards. So because as a chemistry team, most of us are chemists here, and primarily this was focused targeting chemists here. So the key strategies in when we are working on in the lab scale, what should be our outlook when we are looking at a patentable process, or how we protect this IPR, and how we protect our claims with the, because most of the time, if we are a CDMO, most of us are working in different CDMOs. So what we are looking at is how we protect this type of new inventions or new discoveries that through to our clients, and also this is what really helps us in the lab scale. So we need to understand what will be the strategies in identifying if we had done a new novel route or something novel, how we protect it. Means there is a process that you have explained us, but what is a basic strategy that we have to put?
Right. See, there are several possibilities, irrespective of the scale on which you are working. You can go for taking patents from lab scale to the commercial. To obtain a patent, scale is not a factor. You can develop a process at a lab scale. You can file a patent. The patent may get granted. And if you further wish to scale it up, and in the scaling up process, if there is any difference or if there is any improvement in the process, again, you can go for obtaining patents there. Okay. So as such, scale is not a factor for taking or not taking the patents. And then whenever you develop a process, if your process is entirely new, yes, you can very well go for the patent, either after completion of the process or while executing the process itself, you can go for provisional patent. See, today you are working on a process, you might feel that there might be some competition. People, other people might also be working in similar lines. So therefore, whenever you get confidence that yes, my process can be implemented, and I am confident that within about 1 year, this can be fully performed. So you can go for provisional filing. There you will get one year time period. For provisional filing, no need of claims, no need of declaration, nothing is required. Just 1-page abstract and some kind of marginal scheme you can write and submit there. So you get the priority. And suppose if you are developing a process which is not entirely new, but then if there are some changes in the parameters, if those changes make some significant improvement in the process, even with that, you can go for filing patents.
Thank you. And in case, because you have spoken about what is a patent, what is a process patent versus a product patent already in your discussion. So there was one more point that we were looking out was about evergreen patents. So
Yes,
how ethical is this? First is you need to explain us what is an evergreen patent and how ethical or how from a business standpoint is this going ahead with evergreen patents.
Right. See, you might have noticed the which one this Novartis case study. I don't know whether you are aware of Novartis case study or not. Novartis has brought a drug molecule called as imatinib. Then later on, they brought another one, imatinib mesylate, another form, beta form of the drug. And patent was granted, but then it was opposed. Because according to Indian Patent Act, a new form of the known molecule is generally not patentable unless and otherwise it shows enhanced therapeutic efficacy. In this case, Novartis failed to prove the enhanced therapeutic efficacy. So evergreening is a technique generally used by the business people to get more advantage of their patented products. Suppose patent term is only for 20 years. You know that patent will only for 20 years you can enjoy. But how to extend it further? To extend it further, people adopt different ways to overcome that, so that still they can enjoy the benefits. That is called as evergreening. Generally, this evergreening can happen with respect to the new dosages, new forms, or new release systems. In all these cases, it will happen, but in my opinion, this is not correct. Now, the legal framework is very strong in any country, so therefore, it is not that easy.
Okay, and ethically also from business standpoint is not.
Yes, because see, you get 20 years time period to enjoy or to make a benefit out of your investment or your efforts. So then it should be available to the common public also. Because what happens is, if evergreen is practiced, then many people across the globe may not be able to afford the new medications.
Yes.
There are several case studies with respect to this.
Okay. So
this is more applicable for the pharma sector. This is more applicable for the pharma sector and our related areas.
Exactly. So it's always not good ethically, at least.
Yes.
Ethical standpoint that we should not practice evergreening of a patent. I have one more question from a participant. How can I detect and take action if someone copies or uses my patented manufacturing process for a specific product, given that patent details are publicly accessible online? So this is...
I think good question. Patent details are anyway accessible publicly. See, if I have like whatever 43 patents I mentioned, anyone can access my patents. Not only accessing the patents, any activity related to the patent is a highly transparent activity. Whether I paid the fees or not, whether I paid timely or not, if I delayed, how much delay I made, everything is accessible. But now finding whether someone is practicing our patents without our permission or not is a challenge, especially in the countries like India. But once you can find, I think you are on the right track. If you find them, please tell them that I have a patent and still it is an active patent. Until this time, you are not supposed to practice my invention by whatever means it may be. Knowingly or unknowingly, one cannot practice. So you send a notice and hopefully they will come for compromising. If you compromise, you can make the deal. Otherwise, you can go to the court. Yes, it is very well possible. And many times the deal will settle with compromisation. They will try to give some kind of compensation. Then if you are happy, then you can take it forward. Or you can also put them into your team and then take the compensation, go along with. Because already they have identified the market.
Okay. That's the questions. But before we go from a chemistry standpoint, I think there are a lot of, one session will not be enough for such a big topic to cover. So this is a session where we just try to cover the basics of what patent is, how these claims, what are the different types. We had a lot of information on the different topics that you had taken through us. Thanks for this time, and also guests, all the participants, whoever are it's okay, they can even ask Pavan on questions. And if there is nothing, then I would end this topic with a thank you note. Open for anyone who wants to have a direct question.
Yes, you can very well ask any kind of queries that you have. Because what I thought is, maybe being a very first session, I thought of giving some essential aspects on patents.
Yeah.
Each slide, whatever I discussed here, is again a subject of big discussion.
Definitely, we'll keep these sort of webinars not only on IPR but also the burning topics within the industry. So I would request participants to push their thoughts or the questions that they have in mind. We can bring in experts like Dr. Pavan here onto these webinars. We intend to conduct these webinars on a regular basis from Scimplify side, so that we have this sort of interaction with industry and industrial experts who can help us in getting into the knowledge base that we want to build across. So that's one thing. Yeah.
Thank you, Mr. Pavan. But if the matter goes judiciary, then it goes for lifelong in India. No. Not all matters at judiciary will go for lifelong, and these kind of cases will be dealt with immediate action. Okay, there are several instances, but of course, I think in those cases, you may not need to go for that level. They will be mostly settled by compromising. Okay, for you, market is important. They have already identified the market. So if you can get some compensation, you can very well settle the matter. So in India, most of the cases, this is what is going to happening.
And thank you all the audience, and our team will reach out to you in our understanding future, and also check out our LinkedIn and other social media platforms to have these sort of we'll be posting the recording of this session on our social media platforms. But also, if you want to connect with us and give us some ideas on future webinars, we are more welcoming you to give your suggestions on the topics that we wanted to discuss.
Sure, Karthik. Thank you, and we'll be happy to associate with you. Let us offer fruitful association. Thank you.
Thank you, Dr. Pavan, for all this wonderful session and your time. And thanks for all the audience.
Thank you all. Thank you.
Thank you. Bye.